This complete disregard for the law made it impossible for an average citizen to navigate what should be an unbiased legal system. Both of my cases, I feel, have proven systematic abuse, making it clear to me that if you're not in the club, the law is not just discretionary, it's irrelevant. The system left me one option, a legally acquired gripe website. To affirm the decision of the lower court, there must be a question of law. If a question exists in any of your minds, it should be asked right now to stop this cycle of abuse, and after 7 years, finally give me one fair opportunity to respond to something that would call into question what I've said.
Have you ever wondered what happens when an ordinary citizen refuses to back down against a powerful bank? What started as a simple mortgage dispute quickly turned into a legal battle that reached the state's highest court, raising serious questions about free speech, trademark law, and whether large institutions can use the legal system to silence criticism. Representing himself without a lawyer, one man challenged a bank's claims with confidence, forcing judges to examine the limits of the law in a case that could have far-reaching consequences. But was this an act of cyber extortion, or was it a legitimate exercise of free speech? Stay with us as we break down every dramatic moment of this extraordinary courtroom.
On August 16, 2021, Justin and Aaron Riddle were sued by Charter West Bank in the Douglas County District Court of Nebraska on charges of violating the Anti-Cybersquatting Consumer Protection Act, known as ACPA, and trademark infringement. The lawsuit was filed in connection with the couple's registration of a domain related, which they used to host a website titled Corruption Report, following a dispute over a mortgage transaction. In May 2021, Mr. and Mrs. Riddle registered the domain name amidst their ongoing conflict with the bank's management. According to the bank's initial filings, Mr. and Mrs. Riddle reportedly offered to sell the domain back to the institution for $1 million, a move the bank characterized as a ransom demand. During the proceedings, Justin and Aaron Riddle acted as their own counsel. The initial case was heard in the Douglas County District Court, where the judge ruled in favor of the bank and issued a permanent injunction against the couple. On March 29, 2023, Mr. and Mrs. Riddle appealed the decision to the Nebraska Supreme Court.
Very good, then, Mr. Riddle, you may approach.
This opening immediately establishes the conflict. Viewers are introduced to a classic ordinary citizens versus powerful institution narrative, creating instant curiosity about who is actually right.
In debt reduction, we were ready to purchase a home. We worked with Charter West, but at a point in the process, we were uncomfortable with their operation, decided to withdraw our loan and work with a different bank. In retaliation, Charter West put a code in the FHA system that indicated a non-existent child support obligation was past due. This prevented us from consummating our agreement with the new lender, as it's a system that every lender uses, but only the lender who put in the code could fix. After months of bootless requests asking Charter West Bank to correct the record, it was clear they were not going to remove the lie, so I proceeded to file a lawsuit. When it became obvious that we were not being treated fairly by the court, I decided my best course of action was to make a public gripe website. I researched the laws, and once I understood what was allowed, I alone, without the consent or knowledge of my wife, went to GoDaddy and searched for a suitable URL.
Mr. Riddle,
This is one of the video's first emotional moments because Justin frames himself as someone who exhausted every legal option before speaking publicly. Whether viewers agree or disagree, it creates sympathy and raises questions about accountability.
The Lanham Act and a very clearly defined fair use doctrine. Because I'm not a competing business and my site is entirely set up to criticize, I am legally allowed. Charter West has decided to sue us for that website based on the Anti-Cybersquatting Act, which brings us here today. Cybersquatting was the choice for the plaintiff, as it's the one and only way that someone can obtain a website by force. There's no other remedy in law that forces the transfer of internet real estate. However, Charter West has fallen short on their claim on every avenue, and I'll explain how.
just to again be clear for the benefit of our audience, the Cybersquatting Act to which you have referred is part of the Lanham Act, but there are other parts
Certainly.
of the Lanham Act.
Certainly.
And when you were talking about having researched the Lanham Act, you were perhaps talking more broadly than just the Anti-Cybersquatting Act?
The fair use doctrine was more broadly. but as far as the Lanham Act, I was very specific with cyber squatting.
That's, okay, that's what you're talking about.
Correct.
All right, thank you.
Thank you.
Let me just pursue that from a statutory standpoint. So this case is in the playground of the anti-squatting statute. Okay. And there are elements that would need to be proved by a party claim.
Precisely.
Okay. And generally speaking, what are those elements?
Well, to qualify for protection, one must either hold a trademark or be so well recognized on a national or global scale that their name would be sufficient for most individuals to know who they were. Charter West does not hold a trademark to my domain name, although if they did, the fair use is affirmative, and I've proven it several times.
When you say they don't hold a trademark to your domain.
Yeah, they're not trademarked.
Well, I just hold it.
Oh,
So,
sorry.
To be precise, I mean, you don't trademark a domain name. You trademark a name.
Correct.
And your contention is they do not have a trademark for Charter West Bank.
Correct.
So the statute and the cases are referring to mark, not trademark in the.
Service mark, trademark.
Well, they're not fungible. So under the anti-squatting statute, the mark needs to be confusingly similar, right?
That would be one. That would be one
of the elements, right? But it's not the same as trademark of likelihood of confusion. They're not the same. Do you agree?
I would agree, yes.
Thank you.
Thank you, Your Honor. Additionally, notwithstanding the rest of the world, most people in Nebraska don't know whether Charter West is an Oregon-based shipping company, California travel agency, or Nebraska bank, because they're not well known and large, thus disqualifying them from the other prong.
There are two words used in the phrase to which I think you are referring, distinctive or famous. Are you talking about both of those words, or are you talking about just famous?
Famous.
What about distinctive?
It's not trademarked, so it doesn't have there's no protection for that.
When you say it's not trademarked, are you saying there's no evidence that they have a registered trademark?
Correct.
The USPTO?
Would I be able to step to the next prong? I think it'll answer all the questions. Thank you.
Sure.
In case the lack of qualifying conditions does not on its own satisfy the court, there's a second, standalone, fundamentally more important area the claim fails. Public criticism, parody, gripe websites are constitutionally protected activities. When I purchased the site, I immediately started cataloging the way that Charter West had fabricated information to damage us, the little guy. It's easy to explain through a website. I'm going to skip some of this. But in order to win this case, Charter West must prove I was acting in bad faith. This is simply impossible to do based on the factual and legitimate gripe that initiated my complaint prior to purchasing the website.
It seemed that the district court, the state district court, was concerned about the offer to sell the website for $1 million. Does that have any impact?
I'll skip ahead to that. You will see an email string from the plaintiff titled "Settlement Offer Withdrawal" was allowed into evidence despite my objection because, as Judge Durr insisted, quote, "It's not an offer of settlement because there could be some more nefarious information contained," simply meaning that he would allow those emails with an open admission that he could use them as a fishing expedition. So let's just skip to because we're running low.
Before you move on, with regard to your bad faith argument, are you saying there could not be bad faith here because what you were asserting was true?
Correct. It's not only true, it's legal. And I haven't impersonated the bank. I haven't tried to sell bank products. Anything is for sale. If the bank wants to buy the website, I can sell it to them. That's not cyber squatting. I mean, it's defined, and I just haven't done that.
It's defined, and bad faith has 9 statutory factors of bad
Correct.
faith, right? 15 U.S.C. 1125 D1 B little 1. Did I do it? Okay. So, right.
And there are
they're
other
not
things that
exclusive.
can be considered as
Right,
well.
Right, and that is kind of a reference for analytical
Exactly.
purposes. Right. Okay.
And then I would also like to mention, if there's any remaining doubt, all one needs to do is visit www.nissan.com.
This is the intellectual centerpiece of the case. Watching a self-represented citizen confidently explain complex legal principles makes the courtroom exchange surprisingly compelling and keeps the audience invested.
Good morning, Mr. Chief Justice, Your Honors. My name is Jeffrey Silver. I have the privilege of representing Charter West Bank in this matter. This is not a freedom of speech case. This is an internet blackmail case. What this gentleman did was buy a website that he found that, unfortunately for Charter West, they did not have, and he bought this domain site, and he did it for one purpose only, and that was to injure and damage Charter West. The emails that are a part of the record, I think, reflect astonishingly what his bad faith is, if I may.
May I jump ahead? And
Sure.
that is, I think you mentioned this injury to Charter West. What is the injury to Charter West on this record?
The injury to Charter West on the record is the confusion that it's going to cause with respect to its website that it has, that we have in the record.
Is that prospective, or is that already happened?
I'm sorry?
Is that prospective, or has that already happened?
That is, well, in one of his emails, and I'll reference it for you, Mr. Chief Justice, he says the damage is going to happen and we're not even going to know about it. So the fact of the matter is, there may be damage happening to us.
But then you're all speculating.
Well, you can't speculate about the damage because he's telling us in his email that the damage is going to occur and we're not even going to know that it's occurring.
Well, is this your proposition that some navigational miscue results in damage automatically?
No, it's not a navigational miscue. It's an intentional, purposeful attempt by Mr. Riddle to damage the bank by having his website or this website put up and make believe it's Charter West Bank.
But I think you answered it with the answer to, was there evidence of bad faith? And evidently you believe so, and we
Yes,
accept that's your position.
if I may.
But
What about all these cases that seem to say gripe websites are permitted? Do you disagree with those cases, or is this case distinguishable from those?
This is not a gripe site. I understand that gripe sites are okay. If somebody wants to make a gripe site about Charter West being really bad and not doing everything, that's fine. That's certainly protectable. This is not a case about a gripe site.
What distinguished this?
Because in his, if I may, in his, or our exhibit number 3, he says in his email, by next Wednesday, I can absolutely annihilate your client. Please play your game. He does not indicate that he has a problem with Charter West or a problem with Charter West in terms of how it handled his loan, which was already decided by the district court, federal district court, and then held up on appeal by the 8th Circuit. He's wanting to damage Charter West. It's different in my mind from saying a gripe site.
Hold on one second. Isn't that the case for everyone that wants to operate a gripe site? I mean, they're displeased with their experience with the company, and they want other people to know about it. What's problematic about that?
It's not problematic to have a gripe site, but if you look at the context of all the emails, first of all, he buys the domain name, then he wants to sell it, which is exactly what the Anti-Cybersecurity Act talks about.
It's the request for payment.
Yes, is different than just a gripe site. And interestingly enough,
This marks a dramatic turning point. The narrative shifts from a free speech dispute to allegations of cyber extortion, dramatically increasing the stakes and forcing viewers to reconsider both sides.
You know, this was started by Charter West. It was continued by the CFPB, the Department of Banking and Finance, the Fed Reserve of KC, the Attorney General, the Ombudsman, the lower court, and the appeals court in that order. Every single tax-funded agency and safeguard was either incapable of reading or conspired to harm a citizen, leaving only a perfectly documented exploitation by every party. In my original case, the material change was as easy as looking at one single checkbox on one page of one mutilated document, yet somehow 0 over 2 dozen trained experts knew what spoliation is. In this case, it's without question Charter West is to silencing a critic. Everyone, including the lower court, states it. That's an admission, not a cause of action. While representing myself, I've watched as every single legal professional use their training to take advantage of what they mistakenly saw was a weak target. This complete disregard for the law made it impossible for an average citizen to navigate what should be an unbiased legal system. Both of my cases, I feel, have proven systematic abuse, making it clear to me that if you're not in the club, the law is not just discretionary, it's irrelevant. The system left me one option, a legally acquired gripe website. To affirm the decision of the lower court, there must be a question of law.
This is the emotional climax of the entire video. Rather than focusing only on legal arguments, Justin appeals directly to fairness, justice, and equal treatment, making this the most memorable and emotionally powerful moment.
2023, the Nebraska Supreme Court issued a mandate reversing the district court's decision, effectively vacating the permanent injunction against Justin and Aaron Riddle. This appellate victory restored the Riddles' control over their domain and affirmed their right to maintain the corruption report without the threat of judicial censorship. The court's holding turned on a fundamental principle of trademark law, the requirement of a protectable interest. The ruling underscores that the ACPA cannot be weaponized to silence critics when the underlying entity lacks a legally cognizable trademark. In the end, Justin and Aaron Riddle kept their disputed domain name containing the bank's name, as the court found no evidence of bad faith intent to profit or trademark infringement, upholding their right to use the site for consumer criticism. This case presents fundamental questions about trademark distinctiveness and consumer speech in the digital age. Mr. and Mrs. Riddle successfully challenged the bank's standing by asserting that Charter West Bank failed to meet the threshold requirement of protectability. Under the spectrum of distinctiveness, a mark that is merely geographically descriptive, like Charter West, is ineligible for protection under the ACPA unless the plaintiff can prove secondary meaning. Because the bank lacked a federal registration, it was denied the statutory presumption of validity. Consequently, the bank bore the full burden of persuasion to demonstrate by a preponderance of the evidence that the public uniquely associated the mark with their specific institution. The Nebraska Supreme Court's finding of a wholly deficient evidentiary record rendered the bank's claims of bad faith legally insufficient. This reversal
This is the payoff the entire video builds toward. After more than 30 minutes of legal arguments, the final ruling delivers a satisfying conclusion and reinforces the importance of legal standards, free speech protections, and the burden of proof in trademark disputes.